Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as your law intellect. Make sure, well, first of all, let me know if you can hear me because I had a tragic day where my Apple computer that I've had for probably a decade finally said, we have been through legal wars together, Pam, but I'm tired. I am tired. I was in the middle of a meeting, and as I was talking in this meeting, my Apple computer went black. It just went black. And then I'm sitting up there and I was so upset. I'm like, Deb, I haven't even had this computer that long. And he's looking at me and I was like, well, how long have I had this computer? He said, well, before I met you. I was like, oh, okay. Well, so now I had to get on the PC, and I have done Apple my whole legal career, so I don't even know how to use regular computers for real. So I'm glad you guys can hear me, because I was like, oh, it was very sad. So how you have one of those days when I finally finished the meeting, then I had to download certain things on this computer so that I could participate in certain things with my clients and colleagues, and it was just a mess. I mean, I'm glad most of my stuff is up in like software, so I can just get it off the internet, off of their sites directly, but it still was just a headache. So after that, I went and I took a nap, and I said, I'm going to start over. I am going to start over because yeah. So that was my day. I hope you guys had a better day. And I see you, Yellow Boy Smooth, talking about now she usually 15 minutes early. That is true. I usually try to be early. But it was funny when I seen that you said that. That was, sorry, I had to close my door. That was hilarious. So anyway, you guys, for those of you that don't know me, my name is Pam Esquire, also known as your law intellect. Hopefully by this weekend, I'll come back on video, but right now, especially with this PC, I'm just going to keep everything if you can hear me. And my software seems like it's working. I am not going to switch nothing up with any cameras or anything else. So make sure you guys, please hit that like button, subscribe to the platform if you have not done so already. Bull Chat said laptop was tired. Yes, my laptop said, I am going to be with the ancestors. And I was really mad. Like, I haven't had that laptop in forever. Like I had it for a long, probably my entire, well, I'm not going to say that long, but the majority of my career, I've had that same laptop. It is so bad, you guys, that my keys on it, I have so many missing keys on the actual laptop that instead of getting it fixed, because Apple said it costs like $500 to get new key replacements on there because they have to replace the whole keyboard, I went and just bought a wireless keyboard. So I carry my actual laptop and then I carry a wireless keyboard. It was kind of a headache, but I just didn't want to go buy another Apple computer. So now I don't have a choice. And so that's my story. So anyway, you guys see why we are here. We are back talking about, Demetrius said it was time TD, it was missing keys. We are here to discuss the P. Diddy saga that you guys have seen. In the last video I did, if you have not watched it, it was last week around this time. And I discussed how, because of the criminal allegations against Diddy, i.e., his house was raided last week, a couple of his houses, because there wasn't more to that story, I felt like people was using the lawsuit from Rodney Jones, aka Lil Rod, who is the producer. And I didn't really go over that lawsuit very much on my platform or go through it, because some of the stuff to me seems a bit embellished. I'm going to be honest. Secondly, there were it had pictures. It was a whole lot of pages. It seemed like it was drafted for media purposes. And that's how I took it. I felt like there were things in there that if they weren't true, it could lead to some consequences for not being true. And I relayed that to you guys on the platform when we talked about it last week. On last week, we talked about UMG, Lucius Grange, and Motown, and Ethiopia H. And I was messing her name up, and I apologize. I done called the lady Egypt and Asia and everything on that on that video. But her name is Ethiopia, who was a CEO in UMG and Motown. Well, in that lawsuit that Rodney Jones filed against Diddy, there were some allegations that were pretty heavy in that lawsuit. And UMG, Ethiopia, and Motown's attorneys, those defendants are who we're going to talk about even today. They filed a scathing letter. Like, they gave the other attorney, Blackburn, who is the attorney that we'll be discussing, a letter and said, listen, this is not grounded in facts. And we believe that it's being filed, and these facts are in this lawsuit for malicious purposes or for alternate purposes under Rule 11, harassing purposes. They have a whole list. And Blackburn responded. He did an amended complaint. Then he did a second amended complaint. Well, apparently in the second amended complaint, he totally X'd out some of the allegations from the first amended complaint, but everyone has read it already. And then in the second amended complaint, according to the attorney for UMG defendants, they basically said that you totally just abandon those other facts, even though they're out there in this first amended complaint, but you're still adding facts that are not true. We asked you under Rule 11 to withdraw or dismiss us, either withdraw the complaint totally or dismiss us from the lawsuit. Well, the response that they got was basically he was not going to do neither. So then not Blackburn, UMG filed a motion to dismiss the complaint, dismiss those particular defendants, UMG, Motown. Ethiopia was already dismissed with prejudice, and Lucius Grange. A motion to dismiss was filed. And part of the issue was that Jones' attorney did not have permission from the court to even file a second amended complaint. So then Jones' attorney filed a motion with the court to ask the court for permission to file a second amended complaint. And the judge has set a date for next week to have a conference regarding all of this back and forth that have been going with the parties. And I told you all it was dangerous just to take everything in these complaints are allegations. Have people come forth and said things about Diddy and his parties. People have heard it for years. But when you start adding other people into it, and you're not sure if those facts are accurate facts, then you get into a dangerous area. And basically, UMG was giving him the out if they're false, because that's what they're alleging, to give them the out and said, you're doing this to embarrass our clients. And quite frankly, we can look at, I think I was on Twitter, and with Lucius Grange, I've never really followed him or really knew who he was, but apparently he's like, of course, a big person in UMG, but that's where Taylor Swift is. So I noticed that now, since this lawsuit has been filed, there have been pictures surfacing where people have been questioning pictures with him with like Taylor Swift. So it definitely has started to affect reputations of people. And what was bothersome to me is that everyone was intertwining this criminal raid, which is an investigation. Diddy has not been arrested yet. He hasn't been indicted either. And they were intertwining it with the facts that this person, Jones, alleges in this lawsuit, which is two different things between civil and criminal, but I get it. Everyone just wants to report. Well, one of the things that I picked up on Rodney Jones' attorney, like I said, I was like, this complaint is a bit much. There were several pictures. It was very long. I mean, like doing the parties, it would have, this is Ethiopia H. This is her picture. This is so-and-so Grain. This is the picture. It really read like it was written for the public to consume. And that's what I got from it. That was just my opinion. Danielle said, Lucian is one of the biggest persons in the whole music industry, period. Okay. I'm not going to argue with you. But, so that makes it even worse. If that's his position there or whatnot, then that makes it even worse. The attorney for UMG, who did a scathing letter, of which we went over last week, has now filed another letter today advising the court that Jones' attorney recently was just by a judge, has just submitted his name to the grievance committee for doing Rule 11 violations, basically, where you're filing complaints and it feels like you're doing it for media attention is what the allegation is. And it's not grounded in what it's supposed to be according to the federal rules of civil procedures. And you're getting opportunities to withdraw and you don't withdraw. And apparently there were at least, I think, 4 cases of which he allegedly has done this. So the judge refrained from doing Rule 11 sanctions, but did say, I am going to refer you to the grievance committee. So this is the letter that was written. And again, it was just filed. Let me see. It was just filed today. It was filed yesterday. What's today, the 5th? Yeah, it was filed yesterday. And you said, refresh my memory too. Yeah, I've done some entertainment law here and there, mostly contractual work. Yeah. Had me have flashbacks. So this is the letter that was sent. We are counsel to defendants UMG Recordings, Inc., erroneously sued as Universal Music Group, Motown Records, and Sir Lucian Grange, collectively the UMG defendants in the above referenced action. In connection with the telephonic hearing Your Honor has scheduled for April 9th, 2024, we write to bring to Your Honor's attention an opinion and order issued by Judge Coate yesterday, April 3rd, 2024, in the case of Zernzervosky v. Fisher et al., and it has the case number, a copy of which is attached here too. In the order, Judge Coate referred Mr. Blackburn to the grievance committee of the Southern District of New York to address what she found to be a pattern of failing to comply with Rule 11 obligations. And an observation particularly relevant to the offensively false and salacious accusations Mr. Blackburn leveled at our clients, in parens, only to abandon the accusations after having attracted press attention, swapping them out for equally false accusations. Judge Coates specifically stated, a reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. Indeed, his submissions to this court have been rife with disturbing allegations against the defendants and defense counsel. So, to here are Mr. Blackburn's pleading, quote, rife with disturbing allegations, end quote, against the UMG defendants. As the order states, Judge Coe issued a prior order on February 15, 2024, requiring Mr. Blackburn to show cause why Rule 11 sanctions should not be imposed in the case before her. Yet, a mere 11 days later, Mr. Blackburn filed the original complaint in this action, February 26, 2024, followed days later by the first amended complaint on March 4th, 2024, and then his several unauthorized attempts to file a second amended complaint. In every one of these filings or attempted filings in patent violation of Rule 11, Mr. Blackburn larded his pleadings with offensively and knowingly false accusations against the UMG defendants. And it is clear that he knew they were false, as evidenced by his having jettisoned in his proposed second amended complaint every single foundational accusation he made in the original and first amended complaint. So basically, he made accusations against these UMG defendants in the first complaint and the first amended complaint, but then abandoned those accusations and added other accusations. So what they're trying to get the court to see is he knew they was false when he wrote it, is what they're alleging. In my April 1st, 2024 letter to Your Honor opposing Mr. Blackburn's letter motion to amend, I specifically noted some examples of the bad faith of plaintiff and Mr. Blackburn using an unauthorized second amended complaint to garner publicity and only then seeking leave to amend. While I was aware of a pending Rule 11 sanction motion against Mr. Blackburn in the Eastern District of New York, and a motion for a, quote, gag order against him brought by the Fox Rothschild firm, I was not aware of the matter pending before Judge Cote, nor of the other cases referred to by Judge Cote in the order. So, in addition to the cases that was in Judge Cote's order, which we'll read next, apparently, according to this attorney, Mr. Blackburn had Rule 11 sanction motion against him in the Eastern, because we're in the Southern District of New York, and a motion for a gag order, I guess, in another case. It is painfully obvious that Mr. Blackburn believes he is free to flagrantly violate Rule 11 in furtherance of trying to garner press attention for himself without regard for the truth and without regard for the human consequences of his conduct. We have served Mr. Blackburn with a Rule 11 motion, as I had said we would, but this court has the inherent power to address Mr. Blackburn's conduct, and we believe that Judge Cote's opinion and the facts set forth therein are relevant for the court's consideration. So that is the letter advising the court that you need to know that when we have this meeting, because this attorney wants to amend his complaint. So when we have this conference next week to discuss all the back and forth between us, you need to know that what this attorney has been accused of. Yes, it's Lil Rod's attorney, Blackburn. Blackburn also represents someone in a case against Diddy in state court as well. I don't believe that case has even been served yet. Yeah, Tiffany said he can be an overzealous lawyer and Diddy can be a creep. Two things can be true. Yeah, this isn't even, these aren't really referring to Diddy per se. This attorney is hired for his specific UMG defendants. And this attorney is alleging that it's all a lie. Because if you recall from my last video with Ethiopia, it was alleged she went into some room or whatnot at a party, and I guess Ethiopia wasn't even working for them anymore. So there were just certain things that just could not be true. I mean, it just could not be true, you know. So she was dismissed with prejudice. Then it was another thing going all over the internet where everybody said that Ethiopia was actually going to testify. And apparently that was they believe obviously that rumor came from Mr. Blackburn, or Mr. Jones' attorney is who Blackburn is, that came from him somehow. So that's what is being alleged, that he's talked to the media. I don't know how true it is, but that was headlines. And I saw that in a lot of videos where they said Diddy agreed to, that Ethiopia agreed to testify against Diddy. Some people were putting CEO agrees to testify. Well, Ethiopia, she did an affidavit and she said that was a lie. She said she never agreed that she was going to testify against him at all. She doesn't know anything about these accusations being waged against Diddy. So she doesn't have anything to testify to. And she made sure she confirmed that in her affidavit. So I get it. Everybody just, Diddy is the hot topic, but we have to be very careful that we don't put out so much information that's not accurate that it will overshadow where you just don't even believe the things that are true. And I say that all the time. Some people want to believe the worst because they don't like the person. So Diddy has been on the chopping block by everyone since the Cassie situation. He's been the headlines. So because of that, people want to believe everything that are in these lawsuits, which is just an allegation. Just like Diddy is innocent until proven guilty, he hasn't even been arrested or indicted. We don't even know if he will be. He may or may not. But in these civil lawsuits, it's just allegations as of right now. So we just have to be careful when we're reporting this type of stuff. So let me see. So somebody, okay, let me answer this real quick because this is just ridiculous to me. KRP said, don't trust anything Denise Coates says. She's a horrible federal judge, a 77-year-old white woman who is completely out of touch with reality. How do you make that type of a accusation when you don't even know what the facts of why she made her order? Because I haven't even went over it yet. This is the stuff I'm talking about. Like, you can have your bias even towards the judge, but that wasn't even the only accusation that was against him. It was other, as I read in the letter, it's allegedly something in the Eastern District. That's not even where this judge is. It was allegedly something else, and they said a gag order in another case. So, and you don't even know what the accusations are, and the lawyer to make in the actual order, because I'm trying to pull it up now before you make this comment, to even make this comment. Let's just critically think here, because you're proving my point. When people don't like folks, they just want to believe whatever bad is against them. So yeah, that's nice. You can practice in that court. That's cool. That's nice. But you don't even know the accusation. And I think if you are an attorney, because I'm assuming if you say you have practice there, then why would you not know? Why would you just tell me don't believe nothing that this judge says when you don't even know what the allegation is or why she made the conclusion that she made. You also know that they have a big staff in the back there that does, if you've been in their chambers, that does a lot of their work, and a lot of staff attorneys. So let me see. Let me pull this up. So let me go to the order so maybe you could know exactly, because I think this is pretty straightforward. So regardless to what your experience is, to generalize that is pretty jacked up. And you might as well say your whole name so she'll know who you are when you go before her, counselor. So this case is Alexander Zanzerversky. I know I'm butchering it. V. Leanne Fisher. So it says attorney Tyrone A. Blackburn filed this action asserting that jurisdiction exists. This is a jurisdictional issue. That's pretty straightforward. You would agree with me, counsel? Asserting that jurisdiction exists pursuant to 28 U.S.C. section 1332. He did so without conducting a reasonable inquiry to support that assertion. Because this filing appears to be part of a pattern, he will be referred to this court's grievance committee. Background. Plaintiff filed this legal malpractice action on December 14, 2023 against defendant attorneys Leanne Fisher and Michael J. Taubenfeld and their law firm Fisher Taubenfeld LLP. He did so after being advised by defense counsel that complete diversity of citizenship did not exist because the plaintiff and defendant Fisher are both domiciled in New Jersey. On February 9th, defense counsel requested an immediate conference to discuss adverse counsel's abusive tactic and the lack of subject matter jurisdiction. Defense counsel submitted the December 15th email she had sent to Blackburn, repeating her representation to him that defendant Fisher is domiciled in New Jersey. In response, Blackburn filed a notice of voluntary dismissal as to defendant Fisher on February 9th and objected to the request for an immediate conference. So he dismissed it when they told him there was no domicile. So he basically agreed as to Fisher. Blackburn explained that he had voluntarily dismissed the action as to Fisher, even though defense counsel had not produced evidence of Fisher's residence. The dismissal of Fisher did not solve the question regarding jurisdiction. However, since defendant Fisher Taubenman LLP takes the citizenship of its partners, see Platinum Montour Life Science, an order of February 15 directed plaintiff's counsel to show cause while Rule 11 sanctions should not be imposed for his failure to conduct a reasonable inquiry into the defendant's citizenship prior to filing the complaint in this action. The order also listed by docket number 5 other actions Blackburn had filed in this district that have been dismissed for lack of jurisdiction or transferred or dismissed for lack of venue. In a letter of February 16th, Blackburn asserted that he had researched the addresses for the defendants in the instant action by using a LexisNexis people search, which showed Fisher's residence on Broadway. He added that a search of the records of the New York Department of State Division of Corporation showed that Fisher Taubenman LLP is a New York limited liability partnership. At a conference held on March 5th, Blackburn consented to dismissing the action without prejudice. Blackburn explained that he believed that defendant Fisher resided in New York because his client had told him so, and because the LexisNexis search indicated that Suite 750 at 225 Broadway was her current residence. He accepted that what he had done was not an adequate search for the residence of defendant Fisher or the residence of each of the partners of the defendant law firm. So he basically admitted that it wasn't an adequate search on where these people live, because jurisdiction is important as to where you're supposed to file a lawsuit. He was not prepared to address each of the 5 cases listed in the February 15th order. Blackburn was directed to file by March 19th, 1, an affidavit from the plaintiff regarding their discussion of Fisher's residence, and 2, an explanation of his basis for asserting that he had complied with Rule 11 in the 5 cases listed in the February 15th order. Blackburn's submission on March 19th included his client's declaration. The plaintiff represents that he had told Blackburn that defendant Fisher had, quote, shared with me that she lived in the city, end quote. Blackburn also presented a description of the 5 cases which he had filed in this district, but which have been dismissed due to a lack of jurisdiction or a change of venue. Yes, please hit that good like button. Okay, see, you about to get blocked. Cause I can't do it. I can't do it today, because this is what it is. This is about jurisdiction. Jurisdiction is straightforward. That's just what it is. Jurisdiction is straightforward. He's going to go before the grievance. Nobody said he did anything wrong, that the grievance committee is going to do anything wrong. However, this is an allegation that you file things and you put things in complaints, and then it's already out here in public for public consumption that we all read, and you know it shouldn't have been filed there in the first place, because the Southern District of New York, there are a lot of celebrities over there, and a lot of celebrity cases are filed over there. But anyway, let me go to the discussion. Blackburn has, as he admits, failed to meet his Rule 11 obligation in this case. So he admitted that he had, in this specific case that we're talking about, which is not Diddy's, that he failed to meet his Rule 11 obligation. It appears that this is part of a pattern. This is what the court says. The court declines to impose sanctions pursuant to Rule 11 or its inherent power, but will refer him to this court's grievance committee. There is a basis to believe that Blackburn is filing cases in this district without diligently investigating the existence of either jurisdiction or venue as required by Rule 11. So jurisdiction and venue is kind of a basic. It's where your domicile or where your business is incorporated. And to make sure that you have diversity jurisdiction, if you go in the courts for diversity jurisdiction, you have to live in 2 different states. So if we reside in the same state, then you cannot file in federal court. You're going to have to file it in state court. There are certain rules and regulations. So this is the basics. Federal Rules of Civil Procedures 11B provides that by presenting a pleading, written motion, or other paper to this court, an attorney certifies that to the best of his or her knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, it is not being presented for any improper purpose, such as to harass, that the claims and other legal contentions are warranted by existing law, and that the factual contentions have evidentiary support. Rule 11, quote, explicitly and unambiguously imposes an affirmative duty on each attorney to conduct a reasonable inquiry into the viability of a pleading before it is signed, end quote. If an attorney alleges jurisdiction, quote, when reasonable inquiry would show that it did not exist, he may be held liable for sanctions substantial in amount. As this court advised Blackburn, it may, quote, enforce Rule 11 even after the plaintiff has filed a notice of dismissal under 41A1. So this is a situation of which Blackburn allegedly, according to this order, admitted that he had not adhered to the Rule 11 requirement. Blackburn was advised by defense counsel before he filed this action that diversity jurisdiction did not exist because defendant Fisher lives in New Jersey, as does the plaintiff. So the plaintiff and the defendant live in the same state, so there's no diversity. They don't live in separate states. Blackburn had not done a reasonable investigation to satisfy his Rule 11 obligation to confirm the existence of diversity jurisdiction before that conversation, but he abjectly failed to do so after that warning. Blackburn asserts he relied on two sources of information in deciding that Fisher is domiciled in New York: his client and LexisNexis search. He asserts that his client told him that Fisher lived in, quote, New York. The plaintiff asserts that he told Blackburn that Fisher lived in, quote, the city. Neither Blackburn nor his client have described a basis from which Blackburn could reasonably rely on his client to know Fisher's domicile for purposes of establishing diversity jurisdiction. Blackburn's reliance on the LexisNexis search was no more reliable. It is listed as Suite 1700. 225 Broadway is an office building. Indeed, it is the business address of Fisher Taubenfield LLP as shown on the firm's website. Even after conceding that Fisher must be dismissed from this lawsuit because her domicile in New Jersey destroyed diversity jurisdiction, Blackburn sought to pursue this case against her law firm and her law partner. But as a partnership, Fisher's domicile in New Jersey meant there was still no diversity jurisdiction for this lawsuit. This failure to conduct the investigation required by Rule 11 appears to be a pattern. In the February 15th order and at the March 5th conference, this court advised Blackburn that it had identified 5 cases discussed below that he had filed in this district that were dismissed for lack of jurisdiction or because of a change of venue. An order of March 5th directed Blackburn to file a letter regarding his compliance with the requirement of Rule 11 in those cases. Blackburn's March 19th letter response to the March 5th order does not dispel this court's concern. Who said LexisNexis don't lie? If you don't stop. LexisNexis got I think I might have just visited somebody for a week and LexisNexis has it as if it was a resident I lived in. So now. So now the court is going over the case that they're alleging was dismissed based off of jurisdiction. So the first case was Jones v. Fox Rothschild LLP. The Jones v. Fox Rothschild action was transferred to the District of New Jersey in May of 2020, about 5 months after Blackburn filed it in December of 2019 in this district. The defendants were a limited liability partnership organized under the laws of Pennsylvania with offices in New York and New Jersey and an attorney at that firm. The plaintiff had worked in the firm's New Jersey offices and represented that she lived in California when the action was filed. The Honorable Elvin Hellerstein, in the order, transferred the case, noted that the case, quote, includes serious allegations of sexual harassment in New Jersey, attempted rape in New Jersey, and potential failures of the staff of an office located in New Jersey, and that the complaint was bereft of meaningful references to New York. The only allegations relating to New York were that the attorney defendant has sent some of the allegedly improper text messages to the plaintiff while working out of the firm's New York office. And opposing the motion to transfer, the plaintiff had attempted to salvage venue by filing an affidavit containing allegation that Judge Hallerstein found, quote, hard to credit, end quote. In his March 19th letter, Blackburn refers to Fox Rothschild's, quote, domicile as being Pennsylvania, presumably because the firm is organized under Pennsylvania law and based in Philadelphia. This phrasing suggests that Blackburn continues to misunderstand that unlike a corporation, the citizenship of a partnership is determined by the citizenship of each of its partners. The March 19th letter also fails to acknowledge that the lawsuit lacked any meaningful connection to New York. Blackburn appears to take solace from the fact that Judge Hallerstein did not sanction him for filing an action without proper venue in this district. Let me see what some of y'all have to say. I done had to block people and boot people. Thank you so much. Thank you, Dennis. Thank you, Hip Hop Inquirer, aka Dennis, for the super chat. Said, don't play with Pammy Pam. That's all I'm saying. Like, at least come up with, I don't mind meaningful observations and opinions, but when you just give blanket opinions and just straight up bias without knowing what's happening or make conclusory allegations with no facts, that's very concerning. Like, that is very concerning. Like, at least, see, this is so basic. It's literally about jurisdiction. Can jurisdiction get convoluted and complicated? Absolutely. That's why when we talk about the Ernest Williams case and they like jurisdiction, like it's so easy. No, there is a lot. And I told you guys when it comes to jurisdiction. But in federal court, in order to get in federal court, you can only get in there for 2 reasons with subject matter jurisdiction. It has to be diversity, meaning you live in separate states, or you have a constitutional issue, you have a question. And most people get in there for diversity. Like, most of the time it's we live in different states. But the plaintiff and the defendant, because a lot of, especially if you're suing companies, because most corporations are not in the same state that you reside in. So there is a lot when you deal with getting into the courts. It's not just you can file whenever you want to. But for attorneys, it's pretty straightforward, because the other party will tell you, I just want to let you know, if you file it in state court, they may tell you, we're going to transfer and remove it to federal court because we have diversity. And they have the right to do that. Even if you wanted to do it in state court, they remove it, as long as you meet the jurisdictional amount as well, because you have to have damages over $75,000 in federal court as well, which is a lot more than typically in state court. But as long as you're alleging those type of damages, so if you want to stay out of federal court, then say that you're trying to get $74,000 and you can stay in state court. But for the most part, they're going to try to transfer it if you meet the criteria to get in there. But to basically just knock a whole judge based off of, most of the people, first of all, when you get on the federal bench, it's a lifetime appointment. So yes, it is very, very difficult to get them up off that bench. We have people that were 90 years old, and when they get to a certain age, they usually are semi-retired. So they like get 1 or 2 cases, or they start residing over certain things, but you have a lifetime appointment. And so they not getting off the bench. So it's going to be a lot of older judges that are going to be on that bench, and they're going to remain on that bench. Just how the cookie crumbles, Thank you, Analytical One, for the super sticker. I appreciate you. Kim Ann said, will you speak about Diddy's, is that PI threatening TikTokers? I don't know anything about that, so I can't speak to that. I heard somebody say something about he was going to start coming after bloggers or something, but again, it was hearsay within hearsay within hearsay, so I don't know anything, how true any of it is. I will be speculating, Kim. But yeah. Thank you so much, Demetria. I told y'all yesterday I can't run for judge. I can't, because of your comments that you guys have on this Ernest Williams. When we start talking and then we start cackling and stuff, I said they're going to have little clips in their commercials. My opponent will probably do commercials and go on my YouTube and take little clips and say, this is who you want to be a judge. And then you're like showing me imitating people. You guys know how I cut a fool over here. No. I'm going to have to be a judge over here on YouTube. Nope. I could see it, because that's how they do. They get dirty. If you want to be in politics, you need to be squeaky clean from kindergarten. Like, usually your parents kind of raise you. They raise you and gear your life towards being a politician or being elected for, any type of elected position. But no, I could totally see it, because I would probably do it. Just find little clips of me acting all stupid and making faces or whatnot. Like how they do Trump, when Trump starts irritating, like imitating people and acting all ridiculous. That's probably what they would do to me. And I'll be like, the intellects got me out here acting like this. They're like, is this who you want for judge? That's what they would have. Showing Sonia's nails and her demeanor and stuff, talking about her ponytail. Y'all not setting me up to be embarrassed. I'm gonna stay right over here with my little knowledge that I have. Y'all not doing it. I'm not doing it. Ask Dimples 321. Thank you so much for becoming a member. Hold on one second. Hold on. Sorry about that. Thank you so much, Christine Leach. She said, thank you for the breakdown. It helps me for class. Thank you for supporting, and I thank you for the super chat. I appreciate your support. Let's get back to what this judge said that this attorney that just got blocked on my channel was saying that she kooky and I shouldn't believe her because she go after all the black people, because that's pretty much what he was saying with initials. And this okay, so we talked about Rothschild. So the second case that she alleges that Blackburn had jurisdiction wrong was in Weingarten v. CBS. As in Jones and Weingarten v. CBS, the events alleged in the complaint occurred outside of New York. Blackburn filed the Weingarten action in March of 2020. Defense counsel had advised plaintiff's counsel to withdraw the case and refile it in the Western District of Pennsylvania, where the events had occurred. Plaintiff had refused to do so. The defendants then moved to dismiss. CBS's motion to dismiss quoted Judge Hallerstein's language from Jones and noted that, quote, plaintiff's counsel has recently encountered this same issue, end quote. On January 13, 2021, the parties agreed to dismiss the action in its entirety with prejudice. In his March 19th letter, Blackburn states that his involvement in Weingarten was limited to filing a pro hoc vice motion for an out-of-state attorney and that he, quote, did not sign the complaint, end quote, or the motion papers. But his electronic signature does, in fact, appear on the initial complaint, the amended complaint, which was filed after the pro hoc vice was granted, and the memoranda in opposition to each defendant's motion to dismiss. Even if he was not the only or even the lead attorney on the case, Rule 11's requirement applied to any attorney who, quote, presents to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it in. So what Blackburn's defense to this case that was, I guess, dismissed because of lack of jurisdiction was that he was only sponsoring someone to pro hoc vice, which I told you guys, if you're an intellect, you know that you are able to practice in other jurisdiction. Like I'm licensed here in Michigan, but I can go to other jurisdictions if someone will sponsor me for that one time only. That's what pro hoc vice means. And they sponsor you as long as you're in good standing in your own state, and so that you can practice. But oftentimes if I pro hoc vice, I'm the lead on the case. And the person who sponsors you, oftentimes they sit back and they don't really do much. So what he's saying is he just helped someone pro hoc vice in, and he really wasn't a part of the actual action. So this judge said, it doesn't matter if you pro hoc vice in or you were the lead attorney. That's not what Rule 11 says. Anybody who puts their name on it, because we still have to, even when you sponsor somebody, you still have to put your name on every complaint because you're the one with the license to practice there. So they're saying that wasn't a good answer. So there's that. So the third case was Vanderschmidt et al. Versus Higgins et al. And it says the two Vanderschmidt actions asserted subject matter jurisdiction based on diversity of citizenship. The April Vanderschmidt action was filed on April 21st, 2023, and dismissed by the Honorable Jesse Furman for lack of subject matter jurisdiction on May 4th, 2023. As Judge Furman wrote, the plaintiffs amended their complaint twice at the court's direction, quote, but still failed to allege the citizenship of every party. Plaintiffs allege the residence of themselves and the individual defendants, but as the court has repeatedly admonished, allegations of residency alone are insufficient, end quote. A mere 6 days later, the same plaintiff, still represented by Blackburn, filed the May von der Schmidt action against the same defendants. That action was assigned to the Honorable Kevin P. Castell. In a November 30th, 2023 order, Judge Castell noted that Blackburn, quote, on behalf of his client, invokes the court's diversity jurisdiction, but in doing so, and despite the recent dismissal of an overlapping claim against substantially the same defendants before Judge Furman, he fails to allege the citizenship, i.e., the domicile of each client, end quote. Judge Castell further noted that the complaint, quote, artfully disclosed the residency and national citizenship of each plaintiff, but not their domicile. There was also a failure to allege the place of incorporation and principal place of business of the corporate defendant. Judge Castell thus ordered the plaintiffs to produce supporting affidavits indicating when the change in domicile had occurred, the states in which plaintiff filed their tax returns, and the state of their voter registration and driver's license. In a December 3rd letter, Blackburn indicated that the plaintiffs could not produce the required information and therefore requested that the court dismiss the case without prejudice. So when the court told them to produce this information about this domicile of these people, he said he could not do it and he dismissed it without prejudice, meaning, you know, when you dismiss it without prejudice, you can bring it back. Judge Castell did so on December 18th with the caveat that, quote, in the event a new action is filed in this court raising factually related claims against any of the named defendants, plaintiff's counsel shall mark the civil cover sheet of the new action as related to this action and request that it be assigned to Judge Castell. So the judge was like, okay, I'll dismiss it without prejudice, but if you choose to refile it, I'm going to be the judge. You need to put it on the cover sheet that it's supposed to come back to me. And in his March 19th letter to this court, Blackburn blamed the complaint's failure. So he was explaining to this, you know, in this order that we're reading, he was explaining why this happened in this court related to jurisdiction again. So Blackburn says in his March 19th letter to this court, Blackburn blamed the complaint's failure to properly allege diversity to jurisdiction in the von der Schmidt action on the allegedly erratic behavior by one of the plaintiffs in that case. He adds that he had sought to withdraw as counsel for the plaintiff in the May von der Schmidt action. So his reasoning, he said that this ended up being dismissed was because his client's erratic behavior. And he was trying to withdraw out of the case anyway. So the fourth case the judge brought up, where there was some dismissal action because of lack of jurisdiction. Meanwhile, Blackburn filed the Haran case on May 21st, 2023, 17 days after Judge Furman's, quote, repeated admonishments, end quote, about the failure to properly allege citizenship in an action based on diversity. The Haran complaint brought on behalf of New York plaintiff asserted the existence of diversity jurisdiction on the basis of the individual defendant's alleged domicile in New Jersey. Roughly 4 months later, on September 25th, Blackburn requested that the Honorable John Cronin, to whom the case had been assigned, dismiss the case without prejudice because of lack of complete diversity. In the interim, Blackburn had been pursuing entry of a default judgment against the defendants. On September 19th, however, an attorney for the defendants advised the court that the individual defendant was a longtime resident of New York who is registered to vote in New York and has a New York driver's license. Defense counsel added that the location where service on the defendant was attempted was a virtual office in New Jersey. Defense counsel sought to file a motion to dismiss on multiple grounds, including lack of subject matter jurisdiction, and to file a motion to strike scandalous and irrelevant allegation attributing racism to the defendants. Kind of sound like the person I was just on my chat that I had to block. In his September 25th letter to Judge Cronin requesting dismissal of the action, Blackburn explained that his client, quote, knew Haran's domicile to be 35 Journal. Okay, I don't even know. That address is an office building. A simple Google search confirms as much, as does the proof of service filed by Blackburn as an exhibit to his motion for default judgment. Blackburn claims in his March 19th letter to this court that the address was, quote, corroborated by a skip trace search conducted by my process serving company, end quote. He adds that he had, quote, several telephone conversations with the defendant in which she confirmed to him that she resided at the Journal Square address. Blackburn asserts that the Haran case was the only case of the 5 listed in the February 15 order in which he erred regarding an individual's defendant's domicile. So he's saying out of all these cases, this was the only one that he's taking responsibility that he erred when it came to domicile. This was according to Blackburn, because this judge in this motion that was filed in this specific case that we're referring to told him to explain all these other dismissals in these other cases. And so this is the only case, this Haran case, where he acknowledges that he erred regarding an individual's domicile. So now we're into the instant case as the 5th case. Just 11 days after filing the December 3rd, 2023 letter admitting he could not establish diversity in the May Bonder-Schmidt action, Blackburn filed the complaint in this case. As Blackburn has admitted, he failed to comply with his Rule 11 obligation in doing so. Blackburn argues, however, that neither he nor his client gained anything by filing this case in federal instead of state court. The record in this case and the history of his other cases in this district contradict that claim. At the March 5th conference, defense counsel reported that Blackburn had told her he filed this case in federal court because doing so would make the press more likely to pick up on it. A reasonable inference from Blackburn's pattern of behavior is that he improperly files cases in federal court to garner media attention, embarrass defendants with salacious allegations, and pressure defendants to settle quickly. Indeed, his submissions to this court have been rife with disturbing allegations against the defendants and defense counsel. Blackburn has called defense counsel in this action a, quote, disgusting, end quote, racist for rejecting his preferred mediators. In response to this court's order requiring plaintiff to submit an affidavit, quote, regarding the representation made by the plaintiff to counsel regarding Fisher's residence, end quote, Blackburn filed a wholly inappropriate 53-paragraph affidavit containing multiple irrelevant and scandalous accusations against Fisher. Regardless of Blackburn's intentions, his actions in this and prior cases indicate a repeated failure to meet the Rule 11 obligations. And then they have Story v. Cello Holding LLC as the authority, which stands for the proposition that the standard for triggering the award of fees under Rule 11 is objective unreasonableness and is not based on the subjective beliefs of the person making the statement, end quote. Significant resources have been spent by judges of the court and defendants named in actions he has filed to address glaring deficiencies in his filings. A referral to this court's grievance committee is warranted. Conclusion: Tyrone A. Blackburn is referred to the grievance committee of this district for such action as is deemed appropriate. So that is the allegation that is going on with the attorney that is representing Mr. Jones against Diddy, and is the lead complaint where we have heard allegations against Young Miami. We heard against 50 Cent trying to get custody now, I guess, of his child because allegedly his baby mama was supposed to be a worker for Diddy. She alleges she's seeking legal action against whoever for filing this. Then you have the defendants of the UMG defendants. They're claiming that all of this stuff against them is false as well. And they're figuring out what avenues they're going to take because they feel like this has affected the reputation of their clients. So we'll see. We shall see. In the interim, you know what? Go Roro. Thank you so much for the super chat. Hip Hop Inquirer said Jose Baez pro hoc in the Tory Lanez case. Yeah, and he was considered the lead counsel as well. You know, Jose Baez got sued by, I think it was Harvey Weinstein. He got sued by Harvey Weinstein because he came in to represent Harvey Weinstein, and apparently Harvey felt like he took his money because he didn't even go to trial on him. But I think Harvey paid him over $1 million, and he said he didn't get his money back, his money's worth of that representation. It's very interesting. Brianna said, it sounds like Mr. Blackburn uses a lot of templates over and over again without doing thorough research if the document he's filing are relevant. See, with those cases that he's actually, the issue was in that order that the judge decided to refer it to that court's grievance committee. The issue was lack of jurisdiction, meaning that it shouldn't have been filed in that court in the first place. But again, once it's filed, and as he said in the Southern District of New York, it is easy for us to pull up in federal court, period, honestly. If you know that it's there, it is easy for us to pull up those cases. And so if you weren't supposed to file it there in the first place, I don't know, I guess they can try to strike it from the record, but we all do have the complaint. So that is what their grievances are. Again, he's only acknowledging one time. Mr. Blackburn is only acknowledging one time of which he's saying that he erroneously may have filed an error in one of the courts, and he's denying all the other dismissals as being a Rule 11 violation. But in that particular case, he did acknowledge too that he shouldn't have filed it there. But how do you take the facts back that are now a part of the public record? How do you take that back? So let me, this was something else that I thought was interesting as well. That, okay, so somebody filed a post and they put, so crowdsource, this was on Twitter. They said, no need to speculate about at DHS Gov going after Diddy. If you follow at Lil Rod made its lawsuit, his lawyer at Tyrone Blackburn 11 laid out a ton of evidence that was obviously sufficient for a warrant. I went in further with, this is what I'm telling you. People are literally using the information in this complaint as their evidence. And it's not, it is an allegation right now. Everything in there is an allegation. He has not been found liable of anything in here. So we believe in every piece of salaciousness that's in there. Because what happened with the Stevie J situation with the video, I haven't been back to the lawsuit to see what he took out and what he changed with all these amendments. But remember, somebody came out and said, because it was an allegation that Lil Rod saw a video of Stevie J with some white guy. And then the picture of him was in the complaint, and it turned out that it was actually a porn star. It wasn't Stevie J. The porn star came forward and said it was me. So it was like, so I don't know. I'm assuming he took that out of the complaint, but I don't even know what he took out and what he didn't. But apparently, because the complaint is so long that I never really, by the time I got through the first one, he was filing an amendment. And I was like, yeah, this is too much. So then he has the video. This is crowdsourced the truth. That video goes into great detail and shows evidence from the lawsuit. All this stuff is happening now because of the evidence presented and at Lil Rod made his lawsuit. The image of Brandon Paul with drugs in his hand was likely sufficient to obtain an arrest warrant. So people are literally like, this lawsuit is the crux of all this stuff that's happening. So then the attorney Tyrone responds and said, if I wanted to, I could write 50 pages for the RICO section alone. This is him responding on social media, the attorney. This pleading would have been 200 plus pages if I included the evidence I have. The court will grant my leave to amend. UMG will file a motion to dismiss. Then I will crush them with my opposition. So this was like the attorney's response to this guy basically talking about the law, talking about, you know, all the stuff in the lawsuit and how it's enough to get arrest warrants and all of that for Diddy. Lois, you said Attorney Pan family got to get on a plane on the way to Caribbean cruise. Everyone have a wonderful weekend at work, school, home, traveling, and play. Thank you, Lois, for your support, and you enjoy your trip. That sounds good. That sounds fun. Yes, please hit that good like button. Excuse me. So yeah, that is thank you, Christine. See the mods, they said you guys are so welcoming. And again, that's not to say that everything in the lawsuit ain't accurate, but it seemed to me that it was a bit much. That was just my opinion. And if it was laid out to be read for the media, which has happened. So there have been also a few articles I've seen on social media of which they said that statements were made, I guess, by Blackburn on, that he's talked to the media about certain things. And that's the allegation that the UMG defendants are alleging, is that he's speaking to the media. So we shall see. I think he denied in one of them that he submitted the complaint or something beforehand to the media. But so now, and this whole grievance situation just happened 2 days ago that they're alleging, that the judge is reporting him. So you said he was in the shade room comments also. Y'all gotta screenshot them and send them to me, because I'm just interested just to see. I mean, to me, it seemed obvious a lot of this was media directed. Most people that honestly represent attorney, well, I'm not going to say that, because there are many attorneys that I call media whores. That's what I call them. And they just like to be in the media, so I can't say that they're not. I've never been like that, and I have represented, some high profile people, but you would never know, because I don't litigate in the media. Now, after the fact, if I win or something, you might get a nice statement, depending on how the case was, I might brag about a little settlement or something here and there. But during the process, that's not what I try to do. But to each his own. To each his own. Okay, so Diva904 said Tyrone doing the same thing he did with T.I. and Tiny case, being in the media. So in the T.I. and Tiny case, did he represented the person against T.I. and Tiny, I'm assuming? So he's represented someone against T.I. and Tiny. And is that the one where they were accused of some type of essay allegation? Because that'll be interesting. Now I'm gonna have to pull up cases on them, because I heard stuff, that people were saying about them, but I had never really heard of them. A lot of these cases, I never paid attention to the actual lawyers that were on them too. Yes, Elite Leo said he represented the accuser. And T.I. and Tiny, didn't they win that case? Yes, he represented several victims. Okay. I got you. But didn't T.I. and Tiny win that case, or is that case still going? I'm gonna have to look that up. Now I'm a little curious to just see his record out here of them W's. Yes, she has to pay them. Oh my. So the alleged victim has to pay T.I. and Tiny, like has to pay what, their attorney fees or something? Elite Leo? Oh my. That super sucks. Sabrina's attorney. Yeah, I didn't keep up with Elite Leo said, yeah. So now, because you filed this lawsuit against them, now you got to pay attorney fee. And there are consequences sometimes. That's why I said that. Now, man, that's unfortunate. People still hiring them, so listen, they must think he can do something, I guess. Joanna, thank you so much for the Cash App. Tiffany, thank you for the Cash App. Tyra and Simone, you guys sent cash apps yesterday. I hope you guys are in here. I forgot to thank you, but I appreciate all of the love and the support all over here. Yeah. Y'all got, let me see, any more questions about anything before I hop on off of here? That is crazy. Judon said it. If it was about drug use, then how come the warrant wasn't for drugs? Why was it only for surveillance tape? And is that even legal? So I got twofold answer to that. I believe the drug information was because the one guy who allegedly is supposed to be the drug mule got arrested. So I think that's why the person in the social media comments mentioned on Twitter the drugs. The warrant, we have not seen the warrant unless you have. So we really don't know what was on the warrant. So I don't know how you say why it was only for surveillance tapes. I'm going to assume, because from the videos that I saw, it looks like there were electronics at least taken out of the California home. So that you can see that they took them, so you can assume that was on the warrant. But we haven't seen the warrant. So a lot of people talking about it and speculating, this is a former FBI agent or a high profile defense attorney or prosecutor. Like, everybody's speculating as to their experience and how this works. But that doesn't necessarily mean that is the what happens in that case. I mean, since when do the feds just let y'all know, hey, we did A, B, C, D, and E? Go talk about it on YouTube. Like, it doesn't work that way. So I think there's a lot of speculation, or some people were able to find pictures that they zoomed in from videos and they were trying to read what was in the hands of folks and all of that. But for the most part, until and unless, and sometimes they never unseal the warrants, and you never see the affidavit for the warrants either. So we'll never know what was in them. So yeah, thank you, LaVersa, for the cash app, sweetie. I appreciate you as always supporting. I hope I just answered your question. You said, are warrants obtainable? Sometimes a lot of times when they do motions to suppress the warrants, they'll attach them as exhibits, but other times they'll leave them under seal. So it just depends. So that's a depends question as to whether the public will get access. I'm sure people are trying to get access to them now, but he's not indicted or anything. He hasn't, from all we know, there hasn't been any information presented in the grand jury. I mean, the houses just got raided last week. Brown Mama 3186 said the feds don't say anything until the arrest and trial. Yeah. Well, when they actually indict you and you've been arrested, they do give statements, and I know they do that in the Southern District. They do statements, and in those statements, they'll say what the person is accused of in the statements. But beyond that, I haven't known the feds to, and they're the most patient people. For all we know, they could have been watching Diddy since 2000. Like, they are patient. The feds are very patient. They are not in a hurry. That's why when you have a federal case, they have a 98% conviction rate. That's why I have a friend of mine who just won a federal criminal trial. And when he won, I was like, it was a big thing. It was like, wait, what? Because it's a very small percentage it's a small percentage that goes to trial. And then it's a small percentage where you actually win as the defendant. They have a 98% conviction rate. Jasmine said, yeah, Law and Crime doesn't even have the warrant and have been speculated since this broke. Yeah, because you're trying to keep the content going. I mean, but again, if you keep an eye on this case and the back and forth, and it may be what I'm saying, a lot of people don't want to hear, I'm sure, because people want to believe everything's salacious. Like, everybody wants to believe that, and that's what it is. That's why they were talking about Young Miami and her cousin and 50 Cent's baby mama and Stevie J and all these people. To me, it felt like a lot of people were thrown in the lawsuit, and I didn't understand the necessity of throwing information about them, whether it was true or false. Like, you don't have Young Miami on your complaint. You're not accusing her of doing anything to you. So it was just like some of these. Stevie J, you accuse Cuba Gooding Jr. of allegedly touching you. But with Stevie J, you didn't have that accusation against him. So why is he in this complaint? So you can make deductions as to why. I mean, it makes a good story, baby. This is a good Tyler Perry movie now. I think, shoot, the way Blackburn wrote this joint, he can be a good he can be a good writer. He knows how to write, shoot, and make your attention stay on it. Because everybody was flipping those pages. People probably ain't read in years was reading that lawsuit. So yeah. LRB said, yep, feds take their time to gather all the accurate evidence. Yeah, they like to win. They like to win. So Michelle, thank you for the super chat. She said, remember, TMZ once reported there was a secret investigation being done last year, then retracted the story. Yes, I remember that. And it was weird. Somebody said that he was gonna be arrested or something. It was very, you had to pay attention to the keywords that were being used. And then the response was, yeah, he was not under any type of investigation. That Diddy wasn't. So yeah. Brown Mama said the feds really have a motto of we just look at our watch and got time today. They take time as to not mess up with one mistake because they are very meticulous about their case due to the level. Yes, they are very meticulous. I agree with that. Okay, Lovejoy, you're not late. Just hit that replay. Make sure you hit that good like for your girl. And I appreciate that. Audie L said the feds told TMZ to shut it down. TMZ does get a lot of information though. Like, because when we watched the video of, is it Christian Combs' mom? So I think it was Christian. Is it King Combs? I don't even know who that isn't Christian who they call King. Whoever. The mother came out and did a video showing the inside of the house and was saying that her sons, because she claimed both of them were the victims of excessive force and that she has retained counsel. And when you look at the video, it's showing drones all through the house and everything. So they have them taking pictures of, all type of stuff inside the house. And again, like, she was talking about how one of them had the light from the GUN, had it on his chest, on his back and stuff, and how they was pointed at him. But Stevie J said the same thing. He did an interview with TMZ. He said he just so happened to be on the compound. I don't even know why Stevie J keep talking, because you got everybody really speculating now the way you going hard. But he was in the studio and he said that they were putting the beams on him too, and he was just in the studio doing work. It's just amazing me that people was there, but Diddy wasn't. Diddy was the only one not there. You had Stevie J at the studio. You had your boys that were there or whatever. They ended up, one of them had a gun to their back and had to have their hands behind their head, and she was claiming excessive force, and she was hiring an attorney to look into what she believed was excessive force. So, but TMZ had like a video of the inside about how the house looked after the aftermath. Now, what I will say is, typically, believe it or not, when your home gets raided, the feds tear it up to get what they're looking for, and they do not call Molly maids or call your housekeeper or anybody to come fix it up. They just don't. They tear stuff up, and I've seen worse on pictures of them tearing houses up, because you got some that they think you have safes or you got things in walls. So just imagine what they're going to do to get to those safes. So I've seen things that were a lot worse than that. So for them to talk about this was just over excessive, like, because you're a celebrity, what you think they were gonna do? Pick up the pillow and then fluff it back up and put it back on the couch? No, that's not how that goes. You said, heck, P. Diddy got the TMZ intel. A lot of these celebrities, I don't know TMZ particularly, but there are celebrities that have great relationships with some of these media places. And so when they get information that they know is salacious, sometimes they'll call the celebrities and tell them, like, dude, we just got this picture of you with somebody that ain't your wife, whatever, and they'll let them know. So a lot of the stuff is connected. You said I ain't seen Stevie J in the studio since he was with Eve St. Hudson. Why? I'm like, isn't Stevie J trying to get spousal support? Like, what's happening? Isn't he trying to get spousal support right now? What is he doing in the studio exactly? Is he trying to get money from Faith, allegedly? That's what I heard in the media. Maybe it's not true, but Elite said he won spousal support. So yeah. Well, maybe Eve need to go check it. I said Eve. Faith needs to check into maybe he's getting some money over there in the studio, because that's what he said he was doing. He said he was in Diddy's studio on the compound when all this stuff happened. So does it matter where Diddy is charged? I saw that 3 of his homes were raided at the same time. Will he be charged in NYC? Yes. If he's charged, he's innocent until proven guilty, but the actual warrant was out of New York, the Southern District, this, where these lawsuits are being filed by Mr. Blackburn. So yeah, it's in the Southern District of New York is where it's being filed, so that they were executed in other states. So that's why you had Homeland Security that executed the actual warrant. Okay, so Elite Leo said he did work on Summer Walker's album and Diddy's Love album. Diddy's Love album is the focal point of this whole Lil Rod lawsuit, because he alleges he was living with Diddy in all his homes for the last year, and that all this carrying on was happening while he was there, and he was sexually assaulted, and he alleges that there were paid escorts and there were drugs and pink powder, and then to top it all off, Diddy ain't even paying him after he did all that work and he's alleging he endured all of that abusive behavior, and Diddy didn't even pay him his money. So the crux of it and what actually led to it, because I think Lil Rod asked Diddy for a certain amount of money, and Diddy was like, yeah, no, I'm not giving you that amount. So that's supposed to be like what catapulted a lot of this. Brianna said he was hitting on his lawyer and she dropped him. Oh my goodness. Can you do a deep dive on Jenna Ellis, Ken Chesborough, Jeffrey Clark, and the rest of the Trump defense team that got in trouble? Oh, Lord. You want me to be here all day, April Crumpton? So I talked about when we called him the Rico 19 over there in Georgia. I talked about a few of them. I think I talked about Harrison Floyd. I talked about Cuddy. Of course, I talked about Trump. I don't think I talked about everybody, because that was a long indictment as well. It was like 100 pages. So, and then with Trump, like, they always like unmonetize those videos. You put anything about him in anything, and they probably gonna try to do this video just because I mentioned his name. I mean, seriously. So, oh wow. Usher talked about being a part of the parties before he was 17. Well, that's horrible. I mean, we've all pretty much heard we've all heard about the Diddy parties because if you had any gateway, I should say, or know anyone who knows anybody in the industry who knows Diddy and invited to parties, or people have invited you, you just didn't go. Like, I was invited to a party before and I didn't go. I was like, no. And then I tell my clients what I've heard. I don't know if it's true, I mean, or not, because I wasn't there. But I'm just saying the allegations of those parties being wild have been, and I'm saying that just lightly, I'm, wild. But it's been going on for decades, literally. Those allegations have been there. That's not the first time we heard this. I'm sure Lil Rod heard it before he started even going and working for Diddy. Y'all think he heard about these parties? Because who really has not heard about these parties? I just, again, it's alleged because I wasn't there. I don't want Diddy coming for me because I heard he going hard in the paint on folks. But oh yeah, that's another one. That's another one right there. Right. I was invited to a Jamie Foxx party and didn't go because I always heard about his wild ass party. That's it. When you hear about them and you know what they're saying happens, you don't go. So that's why I'm saying, like, we're gonna sit here and we're gonna see how all this stuff unfolds. So you said request withdrawn. So yeah. I'm sure it was all that stuff people used to always say sex, drugs. Oh yeah. Because you had Woodstock, you had the rock stars. It's probably even worse. And then, like, where did you get this from that this was okay? Are we gonna look into, like, with Diddy, where did this stuff come from? Where you even feel like you can even do this stuff? You think that he invented this? Why would he think that he can get away with this? Just hypothetically, I ain't saying he did, but I'm saying where do you think it would have originated from? You think that as a black man, he just thought he could just do stuff like this and get away with it? It's so many moving parts to this. It's going to be very, very interesting just to see how this comes out. But yeah. But anyway, thank you guys for hanging out with your girl as always. Judge Christina Peterson. It's a whole hot mess. I have to look and see if you email me. Again, I got to get another computer because I'm not going to be able to do this. I'm not going to be able to do this PC thing. If you guys didn't hear, my Apple crashed. It won't even come on and say hi, nothing. I was like, can it please just come on for 30 minutes? I had a few things on my actual desktop that I wanted to put into my folders. And so I guess that's just gone because I didn't get a chance to do it. But it is what it is. That's what I get. My little laptop was blinking for like 2 weeks. And it was still just yet holding on, giving me the sign. And I still just kept typing it and using it. Like, it'll be okay. Even though half the screen is blanked out. We'll be fine. So it's my fault that my Apple crashed on me today. Yeah, it's thelawintellects@gmail.com. You can send me an email. Anybody can send me an email if it's something that you want me to discuss. Hopefully, I prefer a lot of stuff that happens in the beginning. And my reasoning is because sometimes it gets very difficult to catch up on cases when I don't get the information from the beginning. So, yeah. So, yeah. Yeah. Oh, somebody was sending me the stuff. This was like a day or two after the raid. He is definitely stoking the fire. Thank you, Tiffany. So it's I guess it's a screenshot from the shade room. And he said, if you know what's coming, he would stop talking. And he was referring to, how King Combs did a story, and in his story he put stop with the cap is what he put on the shade room. And Tyrone Blackburn responded and said, if he knows what's coming, he would stop talking. And then somebody responded to Mr. Blackburn and said, don't nobody know what's coming, so how do you? Y'all are capped like he said. And then Tyrone Blackburn responded with a crying, laughing emoji. So yeah, he all up in these media streets. Yes, hit that like button on your way out, please. I appreciate it. Thank you so much. She said, LRB said, thanks for today's law class. I learned a lot from you today. I am glad. That's what I'm here for. I might not be conventional and everything may not be salacious when it comes to the Diddy thing, but I'm definitely going to keep you guys informed as it moves. Of course, if these defendants are dismissed off the case, then we'll see how it changes, if it does, the trajectory. I don't want any attorney to have any issues with their bar license, so I hope everything is well for them. But it's the grievance committee for the federal court, their grievance committee, I assume, and they can just it doesn't necessarily affect your state ability to practice. It may just be that specific court. I don't know how they're gonna do it, but I hope it works out for them. I don't want anybody who went and put in blood, sweat, and tears to lose or lose their ability to practice anywhere, even if it's just for that court. So I hope it works out for him. Again, hasn't been filed. Mr. Blackburn hasn't been filed liable for anything. But yeah, I did have to snap on some alleged lawyer and block him out my chat because he started out going in and calling people racist and all of that stuff as to why this is happening. I'm like, you haven't even seen the order. Like, how do you said you practice in that district all the time and you practice in that court? That's cool. But how do you come up with conclusions and you're a lawyer and you don't even know what I'm about to say? Unless you know what I'm about to say, because, I don't even care. Like, everybody gets in my chat and they want to tell me because I practiced for 30 years, but then their name is always WWF Hulk Hogan or something. Like, it's never a real name, but everybody always wants to challenge me because they've been practicing for 50 years in whatever county on the internet. Well, child, I could be a Supreme Court justice on the internet. Like, what? I could be a CEO of a major corporation on the internet. So I don't believe what everybody says. You can Google me. Trying to stress me out. I'm just trying to get the information. Start out going in on me. That wasn't cool. But it's all good, y'all. All right, I'm about to get up out of here. You guys have a good evening. I'm thinking about you. If you have my other channel, I think I'm gonna go to the other channel and do maybe I'll wait till tomorrow. I still got a phone call to do on Ernest Williams because I didn't do it today. I just had to take a break. Those conversations really affect my brain cells sometimes. So, right, that's all I'm saying. Okay, Journey said I had an accountant tell me my figures were off. He knows because he's a CPA for 100 years and he's 73 years old. I hear that. Usually hear that early on, but when people lead in, I've been an attorney. I graduated from Harvard. I've done this. I've clerked for the Supreme Court justices. I've done this and done that. It's like, whatever. Like, and can you litigate? What's your W column looking like? How many trials have you conducted? Do you just settle your case or do you actually take people to the mat? Like, it's a lot to this game. Everybody's not a litigator. Some attorneys, and that's not to say that you're less than, but there are some attorneys that really aren't in court like that, but they're still attorneys. They might do paperwork. They might do bonds. They might do municipal bonds. They might do tax. They're tax attorneys. That's what people go back to school for and get a higher Juris Doctorate for, when you do like tax law and all of that. Some people do patent. Like, some people barely go to court because of what their profession is. They don't have to go. So, yeah. You see? It's social media jurors, LRB. I have a couple of videos over there for you to check out. But all right, I'll post it if I can, because I'm still trying to navigate this computer. But I wanted to get that information out for today on Diddy so we can stay updated on the case. And I'm going to holler at you guys next time.